Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha, wishing all the viewers a very happy Independence Day. So today's topic for discussion would be on SEBI insider trading regulations. Now, what is the first thought that crosses your mind when I say or mention insider trading? Is it the famous Rajat Gupta case? Now, who was Mr. Rajat Gupta? The retired head of consulting firm McKinsey and Company and former Goldman Sachs board member who was convicted nearly 7 years ago of insider trading. Now, let me first quickly define insider trading. Now, what do we mean by insider trading? It refers to the act of trading securities of any listed company by any person who has access to price sensitive information, and such information is not available with the general body or the general masses for public viewing. And it further leads and subsequently leads to manipulation of price of securities, personal economic advantage. Now, there were certain regulations that SEBI had come up with by excising power under Section 30 of the SEBI Act of 1992 when it brought into force SEBI prohibition of insider trading regulations. Now, the aim of these regulations was not only in achieve investor protection, but also to curb this menace, this growing menace of insider trading. And it also led to defining certain very important definitions, such as who is a connected person, somebody who has greater access to unpublished price sensitive information. Now, what do we mean by an insider? Someone who is connected. The definition of being an insider being broader than that of a connected person. Now, it includes anybody who is connected with that company, reasonably expected to have access to UPSI. And then what do we mean by price sensitive information? And the list goes on and on. So, joining us today on the virtual amicus in somebody is someone who needs absolutely no introduction. She's a distinguished public M&A corporate attorney who has spent over 9 years of experience, has been a part of the public M&A team at AZB and Partners. She has represented major private equity funds on foreign investment opportunities involving both listed as well as unlisted companies across different sectors in India, including investment structures, entry level strategy, etc. She has assisted clients in structuring transactions and related to tender offers for listed companies, buyouts of private companies, and private equity portfolio investments. Joining us today on the virtual micers is a partner at AZB and Partners, Ms. Sneha Nagvekar. And just to give you all a brief introduction about her micers for today's session, she pursued her LLM Masters from University of Pennsylvania Law School back in 2017. She's done a law BLSLB from Government Law College, Mumbai 2013. Now, as far as her key practice areas are concerned, specializes in corporate mergers and acquisitions, private equity and venture capital, regulatory and securities. Her recent work highlights includes represented Carlyle Group in acquiring a controlling stake in Sequent Scientific Limited from the selling promoters, included an exit offers to the public shareholders in India for a value of approximately USD 224.15 million. Presented Reliance Industries Limited in acquiring a controlling stake in Sterling and Wilson Renewable Energy Limited in 2021. Representing Apollo Global Management Inc. for its ongoing indirect open offer in relation to Federal Mogul Gazette, which is India Limited. Advised the board of directors of Hexaware Technologies Limited in the delisting process undertaken by Bering Private Equity Asia. She also advised Tata Steel on the merger of the erstwhile Bhushan Steel Limited with Tata Steel Limited to effect consolidation of the steel business. Advised Capital Group on all securities laws, compliances, internal restructuring in relation to sale of securities during Mankind Pharma IPO. Wow, some major acquisitions and mergers taken place under her supervision. So thank you, Sneha, for taking out time, for readily saying yes for a session. Anything that you wish to say about our channel before we proceed with the session on insider trading?
No, no, thanks, Jay. That was really an overwhelming introduction and very little for me to say. But yeah, thanks for such kind words on the introduction. I have been following, I mean, for those who know that Jay and I are also batchmates and we knew each other from the law school days. So I think it's great. I think I've seen a couple of shows on your amicus, few of friends, few of colleagues who, I think it's a great way to have education and have information distributed among law students or young lawyers and incoming people. So I think it's a great effort. Kudos to your team for the great work you all do. So thank you.
Well, thank you for all the kind words. Distinguished lawyers who feature like you on our channel have made all the difference. Thank you once again. So we can't wait for the session to begin. The stage is set. The floor is all yours. Over to you.
No, thank you. I think you've set the stage with a lot of expectations. I think I think Jay has already set the floor with the basic introduction on insider trading. What is an insider trading, right? From a layman's perspective, and maybe I'll then move into the relevance of insider trading. And it's a genesis which starts from the American laws and then moves into the Indian laws is what is the regulator's perspective. Insider trading per se is a financial crime, which means that effectively everybody, we're talking about stocks here and we're talking about listed securities here, right? All of us at some point or the other must be trading in securities, must have families who have traditionally traded in securities. Why do we need a regulatory space called insider trading, right? Why does the regulator? Because I mean, it's your wish, your wisdom. You buy stocks, you sell stocks at your convenience. What is the need of an insider trading regulations in any securities market or any financial markets? I think the reason of that goes to the fundamental principle that trading has to be done in terms of parity of information. Certain people may be better placed with certain information on the stocks, and they should not be in a position to exercise leverage while undertaking their transactions, as opposed to the ordinary public, who do not have the same level of information. I think with that mindset, that there got to be parity of information, there got to be absolute transparency when people are trading in stocks and dealing in securities, did the insider trading regulations come in, whether you see the American law, which has been the genesis of the insider trading, or you see the Indian law, because even in India, insider trading has evolved over a significant period of time. SEBI has a Securities Exchange Board of India, which is the regulator for all the securities market and protecting investor interests. You will see that even in India, the securities regulations when it comes to insider trading have evolved over several spheres, right? The initial one was in the 1992. Then several amendments went, the major amendments and overall went in 2000, 2002, to the time when, we came in 2015. The current set of regulations, which came into effect in 2015, they have also been subsequently amended. And I think the only intention what the regulator is trying to do here is to make the law a bit stricter, right? Because, and which we will deal during this session, is that the challenge for the regulator is also to catch hold of people who are doing insider trading. You need to also appreciate that it goes back to the principle of privacy. It goes back to the principle of you may be in possession of certain information which the regulator may not know, right? It's difficult to prove in terms of evidence. I think with those challenges which the regulator has faced, the laws have been tightened over a period of time. And that's just the broad overview on the topic. What is insider trading, as I said, right? And who is an insider? Those are the two basic principles. Insider trading means that anybody who's in possession of unpublished price sensitive information have had the benefit of that information and undertook transactions while in possession of that information, right? And that is the bare rule of law. Every regulation under insider trading is really featured on that. I think I'll also have, I've done a short PPT just to make it simpler for the viewers, which I will project, which is broadly from a perspective, trying to get people on insider trading. Just give me a sec. So I hope it's visible for the viewers.
Perfectly visible. Yeah.
So as we said, the regulator when it comes to insider trading is the Securities and Exchange Board of India. That's your regulator for effectively all the regulator who's vested with the interest to protect the markets and the interests of the investors. Insider trading per se is a financial crime because you are taking advantage of certain information. I think the other word which is quite commonly used is that one trading and the other is UPS, unpublished price sensitive information. Trading under the regs per se is quite broadly defined, right? Which effectively means that buying or selling, that's one and commonly understood. It also means an agreement to buy or sell, right? Or subscribing. So even today I may not buy, I may buy the transaction 15, 20 days later. But if there is an agreement on place between the buyer and seller, that itself is trading. And therefore, if you see, it's not defined because the regulator with the premise, wants to extend the regulations to a larger situations, make it a more stricter. The definition of trading is also quite broad, which covers not just buying and selling, but also agreement to buy and sell. Dealing is the other term, right? And dealing can really be as broad as anything. even if it's an undertaking of a transaction or sharing of information, anything to do with securities is broadly looked as dealing. So the regulator's point is that, forget about just buying and selling. Even if you're trying to undertake a derivative transaction, a leverage transaction, or anything to do with securities, while you are in possession of unpublished price sensitive information, then in some sense you are in violation of insider trading unless you can prove your innocence. And we will come to it in the latter part, right? So therefore, key is to determine what is unpublished price sensitive information. Is it every information to do with the listed company? And just a step back, and which is something which I'll also deal with in the latter slide, is that when we are talking about insider trading, we are primarily talking about free securities, which is securities which are listed on the market, right? Because that is where the principle of parity of information between people who are in possession of the information as company officials and the market or general public at large comes into play. On the next slide, I think comes the key question about, what is securities? Broadly, we spoke about the listed company securities. Insider trading, some aspect of it also applies to companies which are in process of IPO. So where you may have filed your RHP red herring prospectus with the exchanges and SEBI. So that shares and instruments also gets covered. If there are any other marketable securities like, American depository receipts or global depository receipts, they also get covered under the scope of securities. So two principles which we launched, right? One is trading, again, very broadly defined. Then comes securities, again, a very broad ambit, but primarily used to mean when you're dealing in shares of listed company. The third slide, and I think that's the key where everything boils down to, is that what is an unpublished price sensitive information? The most colloquial term which is used in the American context is MNPI. We call it that, material non-public information. So there is two elements to it, right? The way the law defines it. One, that it has to be an information which is not available in public domain. And second is that the information should be material enough to have an impact on the price of the securities when it's leaked in the market. So therefore, is every information UPSI, we call it? No, that's not correct. So I think when you're trying to come within the ambit of insider trading, it's important to see that whether that information tantamounts to UPSI or not, right? So that bifurcation has to be clear when you discuss about insider trading. It's not that you have certain, say, for hypothetically speaking, right? If you have information which is absolutely of nil consequences or something which is absolutely in ordinary course of business of company just issuing some purchase order of minimal value, is that something which is price sensitive, and therefore are you prohibited from trading in the securities of the company? No. But say if the company is going to have a materially massive contract with one of its vendors, right, which is significantly going to, increase its revenue size by 20-25%, and then you go ahead and buy the stock because you know that the minute this or business contract is announced in public domain, then that the stock prices are going to hike. That is effectively insider trading in layman's word, right? Because you being maybe an employee of the company, maybe somebody who is, an advisor to the company who had knowledge about that business contract before it came into public domain and before the prices shoot up and went and got stock from the market. That is what SEBI is trying to prevent, right? Because you took benefit about that information and took what the stock say at a minus 20% rise and the stock went up at, that is precisely the matrix of framework. What I have it on screen are the indicative items, which as per the regulation itself are deemed to be UPSI. One being financial results. Logically, everybody will understand, right? If you are an employee of the company, an advisor to the company, either you could be an auditor to the company, you could be a financial advisor to the company, you could be a lawyer to the company, or a merchant banker advising them on M&A transaction. If you have access to certain financial information of the company and to that extent, then you are effectively considered, financial results are considered to be UPSI, right? Because of their impact. Dividends declaration. So when dividends are declared, they're declared to the market at large, but because somebody who's privy to the information of dividend declaration, that itself is UPSI, right? Changes in capital structure, they have a larger impact on the company's stock. If the company is going to do a rights issue, if the company is going to do bonus, if the company is going to do another pref allotment, those are the matters which have a straight impact on the stock prices, right? And therefore they're considered to be UPSI. Mergers, demergers, delisting, effectively any sort of M&A, which we call it in the more common parlance, is going to have an impact on the stock price. Changes in KNPs, right? If the company is going to get a new CEO, the company is going to get CFO, people would have looked at the Hindenburg report, right? The auditors went ahead and resigned. Auditors are not KNP, but I'm saying those things, the stock market price by 3% went down. Those things are perceived to be things of relevance, which have an impact on the stock prices. The list which you see on the left is more of an indicative list which SEBI has provided, saying that, while it has to be a determination of an information which is material, not in public domain, comes into public domain and may have impact on price. That's the overall embargo, the overrich, broader definition. Within that, we have given you an indicative heads, which could be financial results, dividend, changes in capital structure, merger, demerger, KMP. As per market practice, what is also considered more or less UPSI, because the financial advisors believe that this is something which could have impact on price, like business plans, business initiative, capital expenditure of something which is not an ordinary course of business, financial reports which are covering business plans and other expansion plans, recall of loans, because if there is going to be recall of loans, that means the company is not performing well, which effectively will have an impact on the price and market perception, and the share market price will go down. Or you have certain settlement arrangements which you are going to be looking with banks and other information. So I think as a corporate lawyer, having done this and advised many clients over a period of time, this is the key exercise, right? Everybody knows what is insider trading, but what is UPSI is where the key lies, right? And where we spend time and effort, advising many people in the law firm to say that, okay, whether this information will amount to UPSI versus, it's always a test of facts. It's never a straitjacket answer. There are some which are the straightforward ones, but there could be some which are outliers. It's an interesting assessment every time to see whether this will have an impact or not. But more than the others, I think there has always been a conservative view, given that, how regulated the space is, that people should stay away from trading in the market and the securities if they are in possession of UPSI or something which may be perceived as UPSI. The next slide, which I think, Jay broadly touched upon this, is that we spoke about insider, we spoke about trading, we spoke about UPSI. Now, who is an insider, right, effectively, and who is the one who needs to be worrisome about it? And I think this is one regulation which affects many practices, which affects many stakeholders, so to say. If you say, whether if you are a lawyer who's working with a law firm, you yourself may be an insider to your client who's a listed company, right? If you are a general counsel in a listed company, or in an MNC which has listed stock, you yourself are an insider to the company, right? Because as an employee of the company, you have certain information which the public will not have at large, right? Even if you were saying you are an independent practitioner who's advising a listed company and representing a listed company in the market, to that extent, you may also have certain information on the outcome. So as lawyers, definitely, even if you are in different segments, from law firms to independent practice to working as general counsel, or part of the general counsel group in listed companies, this is one set of regulation which stretches across different practices. And I think what is a connected person? It's a broad definition, but effectively everybody who either are the employees or the advisors to a company in any form and shape, or the board of the company, anybody who has insider access, in simple words to say, about the affairs of the company, is deemed to be an insider, right? Insider is the regulations to make it a broader net, broadly define it to mean that one is a connected person who is an insider, and anybody who has UPSI is also an insider. So connected person per se gets subsumed within the definition of insider the way the regulations are structured. You see it on the screen that effectively anybody who has frequent communication with the officers of the company are considered to be connected person. Anybody who has been in a company in any capacity for the previous 6 months is considered to be a connected person. Deemed connected person also includes relatives, investment trustees, member of the board, and so on and so forth. So a simple way to understand that if you are anyways advising, if you're part of the company, you of course connected persons. And we will come to it in few slides, about how listed companies are really required to follow a code of conduct for their own employees, right? Just to prevent situations of insider trading. So therefore, to understand it in very simple terms, here is a listed company. Everybody who's an employee of the listed company is a connected person and an insider in that sense. Any external advisors to the listed company are also insiders. And on top of that, the third layer is effectively anybody who has access to UPSI is also an insider. So that's broadly about covering the concept of connected persons, deemed connected persons, and insider. I think we spoke about it. The next slide is broadly on defenses, right? But I just want to sum up the discussions which we had so far before we move on to defenses. What does the law provide? The law covers that you should not be trading basis UPSI. That applies to connected persons and it applies to insiders. What the listed companies also do is follow a code of conduct, which is more applicable to all the employees who are classified as designated persons. Broadly, that designated persons, it's another terminology which use that. What does the code of conduct provides for? The code of conduct provides for effectively a mechanism about how the people who are within the listed company should go ahead and obtain a pre-clearance. Right, there are certain compliances that you will have to go. Every code of conduct on every listed company will effectively have a compliance officer. You need to go ahead and approach the compliance officer for the pre-clearance, and once you get the pre-clearance, you will have a certain identified period within which you should undertake the trade. And even when you're trying to approach the compliance officer as the employee of the listed company, you have to make a declaration to the compliance officer saying that you are not in possession of any price sensitive information. So all these concepts are there in the SEBI regulations. They are codified under law. There are implementation processes. The code of conduct there is a model code of conduct which the regulations per se provide. And there is a process and timeline which needs to be followed and monitored. And that's why, I believe that this is one set of regulation which is relevant for anybody who is remotely dealing with the securities market in India. What are trading plans and defenses? Like any other law, right? The insider trading regulations also provide for certain inbuilt defenses. And mind you, right, are the defenses which are there under the law. They are not the exception to the law. The rule of the law and the rule of the land, we say, is that if you are in possession of any unpublished price sensitive information, you should not be dealing in the securities of that company. But there are and the standard of proof is really high when it comes to insider trading, right? When it comes to insider, and the logic of that is because it's very hard for SEBI to prove as matter of evidence in a court of law that you had the information and you acted on basis of that information, right? That intention of mine is very hard to prove, and therefore what the law says presumes. And again, I will like to emphasize, for the word that the law presumes, so to say, that if you are in possession of UPSI, then you have acted and taken the benefit of UPSI while undertaking your trade in this company. So therefore, the law wants the onus on you to prove that, no, I didn't do it. And there are certain defenses which have been outlined under law. So the onus is on the insider. It's assumed and presumed in that sense that if he has UPSI, he's traded basis the UPSI. But having said that, the law does provide you certain defenses. What you'll see on screen are certain defenses which have been outlined. The most standard defense is effectively, I mean, it's an out, a complete out from the insider trading is a trading plan, right? At the beginning of the year itself, if you submit a trading plan to the compliance officer as an insider or an employee of the company, saying that here is my trading plan, here are certain dates on which I will undertake trading, then you are free to follow the trading plan to the T. And you will not be guilty of insider trading because it doesn't matter what information you had at any point in time. You had taken the decision way in advance and informed the compliance officer about the trading plan. So it's effectively having a skeleton at the beginning of the year, say April 1st, saying that throughout the year, here is how I'm going to transact, say on August or September or December or, Jan. No questions asked, a full segue in that sense from a trading perspective if you have submit trading plan. Having said that, practically, not many people use trading plan because the fact still remains, right? We are in a commercial world. Nobody knows how prices will move up and down. There are macro economic factors in terms of, global recession, the war between Ukraine and Russia. Different things have impact on different sectors and prices of stock. So practically speaking, while trading plan is an out from the whole insider trading ambit, not been used in by most people in unlisted companies. Far and few examples of trading plan. The other few examples is like off-market transaction, right? If there have been transactions which are not happening on the exchange, but have happened between two insiders who have been possession of the same UPSI, then there is a difference. Now, that's what I'm saying, right? The principle of insider trading is that there got to be parity of information. One of the defenses with the law says that, okay, I took in transaction with another person, but both of us have the same level of UPSI, which effectively means that there is a parity of information between us. And therefore, that is in a way considered to be a defense because none of us had better information about the company. The presumption is that we still did a more commercial transaction. We don't have better information. Between us, we have the same level of information to do with the company. And therefore, our interstate transaction is a defense in that sense. Again, similarly, you could do a transaction through a block deal window. Block deal is a window on the exchange. There are two windows generally, the bulk window and the block window. Block window is also a method of, settling transactions. So if the transaction has been settled through a block deal window between two insiders, that's one of the defense. The third defense in that sense is a Chinese wall defense, what we call it, and more commercially used because you may have big groups like say Invesco or Vanguard. There may be different teams within the same group, right? There could be an investment arm team, there could be a merchant banking team, there could be a private desk team. So you cannot have the embargo. Some team may have information, but it's not necessary that the other team within the same organization will also have that information. So if you can establish that there is a full Chinese wall, one team is the one who's infused and quote unquote polluted with the UPSI. It's not, and you can prove that the other team had absolutely no idea of the UPSI and they took an independent transaction without the benefit of UPSI, then that works as one more defense. Then ESOPs, right? Because ESOPs are more for the employees. So a more logical corollary that, you cannot prevent people. But even in ESOP, there are a bit more nuances. But if you're just exercising your option and getting shares, then there is a bit of defense there and a free will, right? Because you're entitled to do so. The fifth defense in that sense is regulatory obligations. Say if you have an order of divestment from the regulator, India or abroad, say that you have to divest certain amount of shares, that's considered to be a regulatory obligation. So that's again considered to be in defense. There is a rule of law. There is a presumption that, if you have UPSI, you've taken the benefit. And then there is the defenses which are available for you to say that, I did not take the benefit of UPSI. Either there were Chinese walls created between the organizations. I had a regulatory obligation or statutory obligation to discharge my duties. I traded with person of the same level of information. So on and so forth are other defenses which the law provides for. There are the disclosure obligations, and I'll just come to it in some time. But while I feel like I've covered a large portion of it, what I would also want to summarize at this point before we move on to the disclosure obligation is that the law is far broad defined when it comes to trading, when it comes to insider, when it comes to definition of UPSI. The onus is more on the people in that sense to provide one way or the other. And therefore, it's always better to have a cautious approach. If you seem to be in possession of any information, it's always important to check that, is that information in public domain? And public domain could mean all the disclosures which have been taken, which have been made on the BSE website, the NSE website. There are also certain investor calls and transcripts which have been published. So has that information been cleansed there? So it's not, when you say public domain, you have to take a conscious call that is the market in some form and shape being made available of that information, right? So that's broadly it. And I think it's just has been a very interesting area in that sense, right? Because what SEBI, if you see over the years, if people who've been following, is that you call the WhatsApp leak case, you call in the US the Rajat Gupta case. There have been certain other cases where SEBI has charged people with insider trading, generally on investigations which have been initiated. The idea is that it is somewhere a crime or somewhere market manipulation which goes to the core of how trading in stock has been done and how stock manipulation work. And therefore, just to ensure that there is more transparency and to ensure that there is a more parity in terms of trading, it's a regulation which has been very actively used by the regulator for initiating investigations, right? We have over the years seen a couple of investigations, whether it's a small stock deal, whether it's a last. It's not that insider trading is only limited to the big deals or big MNC transactions, right? We've also seen insider trading notices been issued to stockbrokers. We've seen insider trading notices issued to smaller retail investors, right, who are into trading business. So it's not a regulation which is only limited in that sense for larger or the media transactions. It's also a regulation which effectively goes to the core of a purely plain vanilla retail investors who have been trying to deal in securities. You've seen a lot of stockbroking agencies been also coming within the ambit of investigation. SEBI has broad powers when it comes to insider trading. At least they could examine, could call you for interviews, they could call you for investigation, they could have a search and seizure at your office, they could request you to provide information in terms of your bank statements, your trading details, and your bank accounts. They could come and investigate your office premises. So SEBI does have broad powers. I think the last, when the WhatsApp case, and SEBI is like, what people have seen to be evading the law is through WhatsApp calls, right? And therefore SEBI at some point also wanted to trace the WhatsApp calls and have the recording of WhatsApp calls. It's a fine distinction between the regulator trying to invade privacy, because that's absolute privacy to get call recording and call transcripts. But there has been the regulators losing that we're becoming handicapped to provide evidence, right, that people have traded basis UPSI. We have to demonstrate circumstantial evidence, and we are not able to find direct evidence in that sense, right? But so far, the powers, even the existing powers, are still broad. Mostly the way these things cook up is that SEBI may initiate a show cause notice, SEBI may initiate an investigation, SEBI may gather all the circumstantial evidence of your bank statements, your trading statements, your bank accounts, try to investigate the matter, and then issue a notice where you will have to then prove that why have you not dealt, if you have dealt with the information. I think the only other point which I want to touch base is tipping. Tipping is the common colloquial which is used in the American laws, is effectively that sometimes what people do is that I may not want to trade on my own because everybody knows what insider trading is. I may tip off a friend or a family in that sense, right? So I may pass on the tip, quote unquote, saying that the stock is going to do well, the stock is going to go up, or you should divest the stock because it's going to crash, to a family or a friend or an extended relative or a colleague of at work, right? Or an ex-colleague you've known over the years. That itself is also a violation of the insider trading regulations. So one is your own trading when you are in possession of unpublished price sensitive information. The other is also communicating the unpublished price sensitive information to somebody else. And then that somebody else may act on the stock. So that is also an extension of the regulations, because you may be guilty of tipping somebody else on basis UPSI. So I think these are the more common practices which we have seen over the years. I think the other piece which I will also deal with, I think one of the points on the regulations effectively is there are certain disclosure norms. Primarily, the disclosure norms are applicable to the people who are insiders. So if you acquire securities under over 10 lakhs, you need to make an initial disclosure. If you continue to hold certain securities at the end of the financial year, you need to make certain disclosures. But those are more of regulating the space. When it comes to the law and the provisions to do with law, I think what we broadly discussed are the questions around, or the basic principles which regulate insider trading. So, Jay, more to you.
Very well. So talking about tip-off, I think it was Raja Ratnam who had made millions from the Goldman tip. So it was Rajat Gupta who tipped him off.
Yeah, that's precisely. So I think it's easier to catch, because sometimes people have also become smart, right? Nobody wants to do it on their own account, but then they'll tip off a closet. And that's also what is getting regulated. And that's actually the one which is difficult to catch hold of, right? Because if you do not have, generally in practice, how does tipping off work? I will pick up a phone, mostly a WhatsApp call, to a friend, said, the stock is going to go up. Please trade on the stock. I may have personal dealings with him. Eventually, those dealings could be net off through different ways. But from SEBI's perspective, it's very difficult to prove tip-off, right? That if I'm a family member, I can talk to him about 100 things in life, right? Or a close-end meeting over golf or business meeting. How am I going to prove that I actually did tip off the person? So at the receiving end of that is also for people, right? People like, but I may have spoken to him about something else. Why am I accused of tip-off, right? So it's a constant fight between the regulator and the public at large, because there is some part of the society or school of thought is like, I've been unnecessarily dragged into insider trading investigation when I'm not tip-off. I mean, you cannot refrain me from, I don't know what the trading details of my friends are, right? I don't know how they trade. Everybody trades. It's the most common thing to do and earn out of the financial market. So I think the regulations at one point is that there got to be free flow, and people out there also to make money from the financial markets. But how do you regulate in a manner where there is fair play? So that's always the challenge. And if you see the amendments over the years, they have precisely got it to make it a stricter law to catch hold of the guilty. But sometimes the reality still remains that, there are a lot of other people who may have to go through the processes despite may not be guilty of insider trading.
So broadly, the objective of SEBI has always been investor protection and to curb the menace of insider trading. Now, I had some 3-4 questions, but this brilliant presentation of yours has broadly answered all of them. Just one quick question talking about the WhatsApp case. Now, you on one hand, you have the right to privacy, which is a fundamental right, post Kotazami judgment. And so there's recording that is taking place on WhatsApp, which is again a very private part and a private thing, day-to-day life. And on the other hand, there are certain SEBI powers that it derives from the 92 legislation of seizure and of arrest and of search. So what happens if there's a conflict between the two?
So I think that's what I'm saying. It always gets tested, right? And SEBI's one of the requests in the WhatsApp case is that we should get transcript of the WhatsApp calls, but that was not agreed by SAT to the extent, because that's invading privacy. So either you prove circumstantial evidence to such high threshold that then that demands you invading privacy in, to prevention of market. But if your circumstantial evidence is not that strong enough and doesn't tilt the in your favor the balance, then you will be not allowed. So it's always been tested before SAT or Supreme Court in that matter. The way the appeal framework works, you have the SEBI. If you're not happy with the SEBI decision, then you have to go to SAT. That's the Securities Appellate Tribunal. And if you're not happy with the order of the Securities Appellate Tribunal, then you have to go to the Supreme Court. So that's the foray.
Very well. So, to all the viewers who are watching, what is that one quality that makes a successful lawyer a great lawyer? It is this brilliant ability to simplify complex legal issues, to solve them and to present it in the simplest of the ways. I salute Sneha, for doing all of this, compiling it so beautifully and presenting it in just 35 minutes time. I know it's not easy, but the way you do it, you prove that you're not just a successful corporate attorney, but also a great lawyer. Anything that you wish to say towards, because now that we are at the fag end of our session, as parting words before we wrap this up?
No, I think I'm definitely grateful, Jai, for you to give us the opportunity, to present these topics. Like as I said in the beginning, right? I feel that it really helps for young lawyers to discuss on these topics, because I don't know how much law school education does offer, introduction of all this stuff. It's very different. Like my idea, and on a very honest note, that I did study insider trading regulations back in law school. I'd taken a course in securities law, but my notion and my understanding of insider trading then and now is so different, right? And it's just the experience which makes it makes it more nuanced when you have the practical implications in life. And it's great to share it with a larger forum. I just hope people are benefited with the information.
So to all the viewers who are watching, our email is mentioned on the channel. In case if you still have any queries, feel free to mail to us. We'll be more than happy to forward the same to our micers for today's session. Thank you, Miss Sneha Nagvekar, for taking out time. Wishing you a very happy Independence Day. And
Same to you.
thank you so much once again for the session. The next
Thank
session is
you.
on its way. It's goodbye for now. Thank you.
Thank you.